Evidence Act, Paper Part 2, Refreshing Memory, under examination. A witness may, under examination, refresh his memory by referring to any writing made by himself at the time of the test, the transaction concerning which he is questioned or soon. Afterwards, that the court considered it likely after that transaction was at the time fresh in his memory. The witness may also refer to any such writing made by any other person and read by the witness within the time aforesaid when he read any the knew it to be correct, provided that the court be satisfied that there is sufficient reason for the non-production of the original. An expert may refresh his memory by reference to the professional treatise. In this case, the witness may refresh his memory afterwards that the court considers it likely that the transaction was refreshed in his memory. Leading questions. Section 141 of the Indian Evidence Act 1872 deals with the question terms of leading questions. A leading question is one which states that suggests the answer and puts word in the mouth of the witness. It's a question that prompts or encourages the witness to give a particular answer. Leading question is any question that suggests to the witness the answers that the person poses the question deserves. Leading questions are generally prohibited by the generally prohibited. They are allowed in the cross-examination of a witness and in the examination of a witness who is declared hostile. Leading questions are questions that guide and or prompt the witness to answer in a specific way, often suggesting the desired answer. Situational question. Ms. Rohini was poisoned by her husband. She made a statement implicating her husband's role in killing her before a stranger. Whether Rohini's statement is the dying declaration. Yes, it's a dying declaration. It's a dying declaration because it's a statement made by a declarant as to the cause of his death. If the person making a dying declaration statement is likely to stay alive, his statement is inadmissible as the dying statement is not. But if examined, it could be relied on under Section 158 of Indian Evidence Act 1872 to corroborate its testimony. Thus, this statement is a dying declaration. What is the nature of the dying declaration made by Rohini? If is it admissible in the court? The nature of the dying declaration is that it may be oral or in written forms, and it may be made by the way of science or in the way of verbal communication. The law related to the dying declaration is given under Section 32(1) of the Indian Evidence Act 1872. The general rule is that hearsay evidence is not admissible in court unless the evidence tendered is tested by cross-examination. It is not trustworthy. Note: Section 32(1) of IT Act is an exception to the general rule. Thus, Rohini's dying declaration is not admissible in the court. The advocate of the accused appeared in the case at trial and observed that one of the witnesses tendered the prosecutor himself was narrating to be the court that what the dumb witness had seen at the crime scene. Hence, such a witness testify in the court, explain using the relevant provisions. A dumb witness is someone who is physically challenged, incapable of speaking due to illness or injury, or even if he is mute. A legal context, a dumb witness does not mean someone who is lacking intelligence, but rather he is an individual who cannot give facial oral evidence because they are mute. Section 113 of the Indian Evidence Act talks about the dumb witness who can testify in court. 2. What is the prosecution correct in narrating the witness had seen? Explain why. The prosecution is correct in narrating what the witness had seen. It's because the prosecution himself has observed that the witness is a dumb person. Also, the prosecution found that the witness was a dumb, so he must have some difficulty in speaking. Therefore, according to me, the prosecution is correct in proving that the person is a dumb person. Define evidence. Explain different types of evidence along with its evidentiary value. all statements which the court permits or requires to be before it by the witness in order to in relation to the matters of fact under the inquiry is called evidence. The different types of evidence are stated below. Oral evidence. Oral evidence pertains to spoken statements and can be stand alone as a proof of the need for supporting documents. Primary oral evidence is first-hand acquired through a witness or its own sensory perception. Documentary evidence. Documentary evidence encompasses any material that conveys information through writing, symbols, or other means of recording. It substantiated contested facts in a legal proceeding. Evidentiary value of evidence are primary evidence. Primary evidence means production of the original material, production of the original electronic record means the production of the document itself. Secondary evidence, production of the computer's output of the contents of the electronic record. Secondary evidence, many of the times it's practically impossible for evidence in the court because of hard disks, big servers, hence the open court is permitted secondary evidence also. The secondary evidence can be taken to the court through printouts on papers, copying and storing on the magnetic or optical media produced by an electronic device. Explain estoppel and explain its types of estoppel. An estoppel is a principle whereby a party is produced from denying the existence of some state of facts which has been formally admitted. According to estoppel, includes one from accruing anything contrary to the claims made or act done previously by that person. Types of estoppel. Estoppel by record. It's also known as estoppel by quasi-record. A matter of record is that something that is part of the record of the court. As proof of the recording, estoppel results from judgments of competent courts. Where the earlier record was that the court of record, the resulting estoppel is said to be recorded, and where it is of any tribunal, the estoppel is said to be quasi-record. Estoppel by deed. Where the parties agreed on the true construction of the deed, then rather neither he or his represented can deny such facts. Estoppel in dias. It's also known as estoppel by conduct, where one has either by word or conduct made another representation of fact. Either in the knowledge of his falsehood, he has conducted himself. Estoppel that arises by way of election. When a party makes a selection between two legal rights, whether it's by choosing one right and abandoning the other, by this law, a person may be precluded from ascertaining a legal right to which he could have had it. Thank you.